How did you get involved with law, Kesh?
It's interesting. I was practicing law at the time, and it's when I actually first realized there was a need for this type of specialty finance, what's known out there as litigation funding or non-recourse funding or pre-settlement funding.
Were you doing plaintiff's personal injury?
I was. I was representing plaintiffs who were injured in accidents or injured due to medical malpractice, things like that. And at the time, my clients would come to me and say, you know, Mr. Kornhaber, I know you're working very hard on my case, and I know these cases take years to resolve, but I need some money now. I'm having trouble paying my rent or my mortgage, or my daughter's college tuition is due, and I know my case is going to be worth money down the road, but I need some money now. Could I borrow money from you? You say my case is strong. And
isn't it amazing? It's a problem that I deal with, I don't want to say every day, but definitely every week, where clients assume that because you're handling their case and there's an expectation they're going to receive money, that maybe you can loan or advance money, and you just can't do that.
It's against the rules of ethics in just about every state that an attorney cannot lend their own client money. It creates a conflict of interest.
Absolutely. So what happened? You decided to leave the practice of law, or?
Decided to leave the practice of law and to get into specialty finance, what's known as litigation funding. It's an interesting industry. Those same clients who came to me when they were my clients looking for money were unable to go to a bank and borrow money. They didn't have the credit worthiness, and they've exhausted their other resources.
Well, you know what it is, you know, when you have somebody who's been, let's say, seriously injured, and they're out of work, you know, and as a result of being out of work, the income's not coming in like it was. They're not paying the mortgage or the rent, utilities, you name it. That's piling up. Sometimes they get a little desperate. And I think that that is probably what prompted the growth of this industry, litigation funding.
It's true. You know, these individuals were physically injured, emotionally injured, and their credit was being damaged as well.
Absolutely.
A lot of these individuals were also working, you know, 9 to 5, and then working overtime and supplementing their salary with overtime. And then they go on disability, and they're taking home maybe 60% of what they were bringing home before the accident.
Through no fault of their own, that they're in this predicament. Now, LawCash has been around how long?
About 9 years now.
And how long have you been there?
I've been there about 7 years.
Okay.
And yeah, like you mentioned, it's now a thriving industry. It's become prevalent in the practice of litigation and also quite accepted in litigation. You know, there are controversial aspects of it, and it has to be done responsibly and ethically.
Well, I think there are a lot of misconceptions about it. I think that the legal community has a lot of misconceptions.
Right.
And I think they're just like any other business. There are probably good and bad parts. It's not for everybody.
That's right. It should be more of a last resort type of thing.
And how do you, you know, LawCash decide if a case is a good candidate or if a plaintiff is a good candidate?
When an individual contacts us to see if they could obtain an advance against their future potential recovery against their personal injury case, we look at 3 things. We look at the liability of the case, meaning what happened and who's at fault, the damages, which in cases like this are typically their injuries, and how much insurance coverage is available. We look at those 3 aspects. We have attorneys who work for us, they're our underwriters, and we come up with how much we feel the claim is ultimately going to settle for. And then we'll consider an advance of up to about 10% of what that projected settlement value is.
Now, what's the difference between the advance that your company makes and a loan?
It's actually a distinct difference. In order to constitute a loan, there must be what's known as an absolute obligation of repayment. With non-recourse funding or pre-settlement funding, if we advance money to an individual with a case and the case is lost, we don't get our money back. We have no recourse to go after the individual or their personal assets. So it's very risky and also expensive to sort of offset that risk.
And what about if you said if a case is lost? What about if a case is discontinued or dropped?
If the case is discontinued or dropped, then we also lose our money. If it's dropped and then reinstated again, we try to follow that and you know, try to get our money back, call it a quirk. We like our money back every once in a while, but you know, again, if it's done responsibly and ethically, it could be such a valuable resource and tool for these individuals. And the reason I say that is, I speak to lawyers every day from around the country, and there's a common theme that I'm hearing, which is these cases are taking longer and longer to resolve. And we looked into it, and we know why. It's for financial reasons. The insurance companies that are ultimately going to settle these cases are holding on to all of their money and investing those dollars, and they're earning interest, and at the same time, they're putting financial pressure on the individual, and at some point, they're going to make, as you know, a lowball settlement offer and try to make that individual take as little as possible in terms of the settlement.
You're preaching to the choir, because I'm the one who's always telling clients that the insurance companies are, just like any other business, trying to make money and save money. And they're, in my opinion, not looking out for a way to adequately compensate somebody quickly and fairly. They make money from their money. What kind of success stories do you have?
One that comes to mind, we're talking about lowball settlements. I was in Orlando, Florida at a national conference of trial lawyers, and I was approached by an attorney from Mississippi, and he was asking, what does your company do and how does it work? And I was just like this, just going through it. And I mentioned lowball settlements, and he said, called over one of his associates. He said, ma'am, tell Mr. Kornhaber about our client so-and-so. And they told me the story, and he said to me, I think this case has a settlement value of, in excess of $500,000. And we're about a year away from getting, finished with discovery and being in what's called the trial part.
Let me guess, and there was a $100,000 offer on the table. So
they were a little more generous, about a $125,000 offer.
Okay.
So we got back to our offices, and he sent us some information on the case. We did our review, liability, damages, insurance coverage. We felt the case was worth well in excess of $500,000. The client came to us and said, I need $25,000 to survive financially for the next 12 months to be able to pay my mortgage and keep the lights on and bring food to the table. So we did the $25,000 advance. 12 months later, the attorney settled the case for $800,000.
Wow.
And he actually provided us with a testimonial, and he brought it back to his office, and they talk about other instances to remember to use pre-settlement funding or non-recourse funding to prevent lowball settlements. It's leveling the playing field on a case-by-case basis.
But why shouldn't that, why shouldn't a plaintiff go through litigation funding?
It's very expensive. The truth is, to offset that high risk, there are high rates. And the rates generally in the industry range from between 2 to 6% per month. We're right around 3% a month. There are no monthly payments. So the fees that accrue every month are added to the principal, and it's compounded monthly. So every month, the amount owed grows and grows and grows. So you have to be very careful about how much you take.
Right.
Because, again, you don't want to get in the way of settling the case down the road.
That's true, and that I've seen the situation where a client needed funding, and the case had a value, not a very high value, maybe a $50,000 value, and we warn our clients right up front. We say, look, when the time comes when we do have that offer on the table for you, you cannot use this as a factor in determining whether or not you're going to sign that release and accept this offer. The value of your case does not go up because you owe money to a company like WellCash.
Correct.
And it can become a problem, but I think that if the plaintiffs are educated by the attorneys, they're given that explanation, because I've seen the paperwork, it can be confusing, and ultimately you're talking about somebody who's desperate.
Right.
I don't want to lose my house. I need the money, whatever it is. We generally don't have any problems that come to mind.
Again, as an attorney who represented clients just like yours, I'm sensitive to your issues. I know what your issues and concerns are. And we've evolved. And our funding agreements now have in bold print a repayment schedule on the first page. We believe in full disclosure and transparency. We have a 5-day right of rescission. If your client takes money from us and then has a change of heart, if they say within 5 days, you know what, this isn't for me, they can return the money at no cost to them. And again, the repayment schedule will show them in bold print, if you take X amount of dollars today, this is how much it turns into every 90 days for 3 years. And that number will more than double. And we have more clients now than ever saying, no, thank you, that's too expensive. And we say, good. We would rather you say no now than complain to you and me a year and a half later saying, I didn't know what I was getting myself into. We want your clients, like you mentioned, making informed, educated decisions.